Okay, so this video is on 10 misconceptions, popularly held misconceptions, about the Employment Tribunal and what it can do for you and what it can't do for you as part of your Employment Tribunal claim. So let's get stuck into it. Number one, subject access requests versus disclosure. A lot of people get confused about this. The tribunal will manage the disclosure process. It cannot assist you with a subject access request. Now, for those of you who don't know, a subject access request is your right to find out what your ex-employer or employer holds about you in terms of information. So, for example, emails about your performance or correspondence between your line manager and another manager about you. You have a right to know what that information is. And you can make a subject access request at any time. And you have the right under the UK GDPR Article 15 regulations or under the Data Protection Act. Now, the disclosure process is something that the tribunal manage, originating from the civil procedure rules, but obviously managed within the tribunal rules. Now, the Civil Procedure Rules and the Disclosure Act manage disclosure in the court system, and it's a process which the tribunal judge will order as part of usually the case management hearing, or if you're just taking a very straightforward contract dispute prior to the main substantive hearing. The disclosure process is useful for a claimant because you can ask your employer or ex-employer to produce documents which assist your case, and you have to produce documents which either assist your case or assist their case. The duty is on both sides. As the claimant, you should really lead, but both sides will have to swap information that they hold, which is useful to their case or which is useful to the other side's case. The subject access request is usually made before you start a tribunal claim, and it gives you an opportunity to see what evidence there is to support your claims which will become part of your ET1. Okay, so if you have an issue with an ex-employer who is not complying with a subject access request, then you have to refer that to the Information Commissioner's Office. And if you have a problem with disclosure, you refer it to the Employment Tribunal and you ask them for a specific order for disclosure. Okay, second one is the ET only has power to hear a certain number of complaints. They cannot hear anything like pretty much you would proceed in a civil court. So it's not a court to hear negligence claims. For example, if they have damaged your mental health, you wouldn't bring a negligence claim in the Employment Tribunal. So you would bring claims of unfair dismissal, wrongful dismissal, discrimination, whistleblowing, those kind of claims. Number three is the tribunal can only hear complaints that you raise in your ET1, in your grounds of claim. So they cannot hear any other claim. So if you get to a substantive hearing on an unfair dismissal claim and you suddenly say, Mr. Judge, I have a discrimination claim as well, a part of this, then you won't get anywhere. If you have filed your ET1 and you wish to change the claims that you bring by either taking away some or adding others, you have to make a separate application to the tribunal and they will consider it. It's not always guaranteed that you will be granted permission to change your claim, but amending the claim form is an application process. Once the ET1 is written, the idea is that it stays written and those will become your claims which the tribunal will hear. Number four is the kitchen sink approach. So most people will take an approach, and lawyers are included in this. Most people will take an approach to throw as much mud at the wall as they possibly can. Let's throw every claim we can possibly think of in our ET1 and we'll write them all down and then we'll worry about proving them later. That really is a bad idea. You should take your claims which you think you have the strongest evidence to prove, so your strongest claims, forward into the ET1 and not throw everything at it. The problem with throwing everything at it is you will tie yourself up in knots. You will try to get yourself into a position where you can prove everything and you probably end up proving nothing. And so you will do your claim more harm than good. So don't throw the kitchen sink at it. And finally, for this video, number 5 is the tribunal is a court, and so it's formal. So there have been situations where, particularly for video hearings, people will get up and make a cup of tea, or they'll start to eat a sandwich halfway through the hearing. It's just not acceptable. You just cannot do that. You have to treat the tribunal with the respect that you would treat any other court system. And if you were appearing in the High Court, or you were appearing in the County Court, or you were appearing in the Court of Appeal, you just wouldn't get up and make a cup of tea. So tribunal hearings are formal proceedings. Now look out for my video for part 2 of the 10 most misconceptions.